For more on these legal issues, we are joined now by Bruce Fein. He's a constitutional lawyer here in Washington. He knows all the ins and outs of this sort of thing. You helped draft some of the articles of impeachment in the Clinton case. Is there a case to be made here based on the Mueller report? You've read it.
Well, it's arguable. It comes close to the line, it may be, of obstruction of justice. The difference, Mike, between this case and, say, Nixon, which I was involved in, there, the president on tape was directing his subordinates to commit perjury. In this case, really, Trump was saved by really almost 15 or 20 people who refused to execute his orders, which were basically intending to obstruct justice. So the fact is, despite all of the sound and fury we heard from Mr. Trump, nobody interfered whatsoever in any decision made by Mr. Mueller. In regard to the redactions, those weren't Mr. Mueller's. They were done by Mr. Trump or by the Attorney General. They were outside. So in that sense, the system worked. There was no way in which any tactical or strategic decision was interfered with Mr. Mueller, and also, to Mr. Trump's benefit, he didn't invoke executive privilege, which he arguably could have done. Now, if I could just complete here, because this is important. People said, well, it's true that, but Mr. Trump was never put under oath to depose things. He gave inadequate answers and interrogatories. 30 times he said he couldn't remember, which is what you do when you're a lawyer. You tell your accountant, well, I don't quite remember X, Y, Z. But and I believe this is true, Mr. Mueller explained the reason why he didn't try to get to deposition. He thought it was superfluous, that what was in the public domain was pretty clear what Trump was intending to do with all these things. You have to be rather dense and obtuse not to see that, the statement after statement in the public press. And the time it would be needed to litigate was too long. And as again, having read the report as I have, I don't think there's anything to add. It's a case where you could decide one way or the other because there were efforts to obstruct, but none of them succeeded because people were not responding to his overtures. Whether that's enough to remove a president from office, I don't know. But this is one thing to remember. It's not an exoneration in the sense that legally they found him not guilty.
Right.
Once he leaves office or something else happened,
right.
This issue could come again because it's not double jeopardy since there wasn't any effort to prosecute at all.
Do you suspect Mueller will testify on Capitol Hill?
Oh, yes.
What's likely to come out of that, do you think?
Well, I think he will be asked to explain why he didn't decide one way or the other. Although he went out of his way to say, this is not an exoneration. I do not feel that it's appropriate for me to comment one way or the other. In part, I think that was fair. Because if he said Mr. Trump he thinks he's committed obstruction, well, Mr. Trump hasn't had a response. It's an accusation, and so it tars Mr. Trump without due process. That was why the Watergate Special Prosecution Force also, when they issued the report, didn't name anybody that they actually weren't going to prosecute who could clear their name. But the whole thing, to my mind, Mike, is totally upside down because the Department of Justice is there to investigate crimes. Impeachable offenses are for the House of Representatives. The chairman, Mr. Nadler, was off base when he said, now it's up to us to do our job. Mr. Nadler, impeachment has always been your job. You could have been running your own investigation. Remember, Mike, that the House of Representatives has even more power than a special counsel. They not only can issue subpoenas and grant immunity, the scope of what they can investigate is way beyond crime.
But they're not going to execute it, you don't think?
No, I don't, because I think politically they feel that whether or not there's legal vulnerability that's still outstanding against Trump, people are just tired of this. They don't want to hear it again. You know, and the House Judiciary Committee would probably be confronted with legal questions about how you're going to enforce subpoenas, and it could take well past 2020. So why are you going to do this? The other element that comes into play, Mike, is that everyone knows the Senate being controlled by Republicans, there's no way you're going to get a 2/3 vote to convict. So at best, you could get an impeachment article and President Trump's still going to remain in the White House.
And it's just dropped. What about the Attorney General? A lot of people saying MAGA, Make America Great Again. Bill Barr himself, William Barr, has made it to make allegations go away. Yeah. Has he lost all credibility, you think?
I think he's shown himself to be a partisan. I think, for example, Mike, he wrote this summary letter, 4 pages, in advance of the release of the redacted report. There's nothing in the regulations that you're supposed to write a summary. Why did you say anything at all? And I think he was being disingenuous when he said, since Mueller didn't pronounce a definitive verdict on obstruction, I will. Why? Why did you have to say anything at all about it? In my mind, he shouldn't have said anything at all about it, either party, because it's an impeachment issue, and impeachment is for the House, not for the special prosecutor or the Attorney General, for that matter. So there's no doubt that Mr. Barr did make this decision because he thought, hey, it would give the president, some more breathing room.
All right, always a delight to see you. Thanks so much for your analysis.
Thank you, Mike.